The Supreme Court was not all that supreme in 1800. As we have seen, it was not an impressive gig, and luminaries like John Jay would rather be governor of New York than Chief Justice of the United States. True, the court had established some important boundaries. For instance, when John Jay refused to give President Washington an opinion on the legality of his neutrality proclamation on the grounds of separation of powers. But by that time, the federal judges were busy enforcing the Sedition Act to root out Democratic Republicans. And the federal judiciary was thought to be a partisan institution, not unlike the royal judges of old. And it's not just that, of course, but also the setback, say, in Chisholm v. Georgia, where they're rebuffed by constitutional amendment. So you have a number of problems with the Supreme Court going into 1800, and it certainly was not anything like a supreme court. If anything, it had a long way to go before it could even be regarded as a co-equal branch of government. Now, this lecture will give a short history of how John Marshall began the process of navigating that change. And it really is John Marshall who creates the modern Supreme Court. He does so in various ways, not the least of which is just being Chief Justice for a period of 34 years. But more importantly, he does so in ways that fundamentally change the nature of the court. So despite its early independence, despite, in fact, its rebuffs and the problems that it faced going into 1801, John Marshall will end up being tremendously important. And we will focus this lecture on him. And the Federalists did try to shore up the judiciary in the aftermath of the election of 1800. They were aware that their national majorities had evaporated, and the Federalists therefore pressed the Judiciary Act of 1801. Now, among the other things, the Judiciary Act ended the process of Supreme Court justices riding circuit. It established an intermediary level of circuit courts, as well as new lower court federal judgeships and justice of the peaceships. The goal was twofold. One was to shore up the actual Supreme Court, to give the justices a permanent seat in Washington. This seemed reasonable enough, especially given that the whole circuit riding enterprise had really been the result of the first Congress's parsimoniousness, or its cheapness, really. The second goal of the Federalists was to quickly stock all of these new posts with Federalists, which the Federalist-controlled Senate did rapidly in the last week of its terms in February 1801. Now think about this for a second. This means that what the Federalist Sixth Congress is doing, where they have that majority, which they know by February, they know by January, they know by December for that point, that they are going to be thrown out of office. This is when they start stocking not just the judiciary but also the civil service with Federalists. So Thomas Jefferson in this mess kind of faces a dilemma. He has all of these Federalists now in the civil service. And because, of course, the entire civil service, including the judiciary, is stocked with Federalists, they might undermine his government and the changes that are coming. And already, by the way, Federalists are grumbling and urging schemes of disunion. So the idea that he could just simply come in and throw everybody out of office also is problematic. And remember, we're still dealing with that problem of the peaceful transfer of power and precisely what it means to have a change of power in a Republican government. This is not something that will be solved, by the way, by this, but it's an important episode. Jefferson's policy took two tacks. First of all, he set a deadline of December 12, 1800. And December 12, 1800 was the date that Adams knew he had been defeated in the presidential election. And then what he did is he said that all civil appointments made before that date were valid. All those made afterward he considered to be in bad faith, and those would be considered nullities. Now, from this, by the way, he exempts judges, and I'll come back to this. Judges had been appointed for life tenures, and that was different. Second, he removed Federalist marshals and district attorneys who had committed legal oppression under the Sedition Act. And this is actually a very important part of what Jefferson does. It's part of his constitutional program. I need to specify this. Jefferson initially actually had in his address, his inaugural address, a lengthy passage about the unconstitutionality of the Sedition Act. He removed it because he didn't want to be too provocative. But his policy, once he comes in, is to remove those district attorneys, and federal marshals who had been zealous in its prosecution. So he essentially uses the executive power to get rid of those officers that were enforcing that law he felt too zealously. And the second, actually, is to take a number of other steps against the Sedition Act. And this involves pardoning two men convicted under the Sedition Act, and then telling his attorney generals that they will no longer seek any prosecutions under it. The law actually expires when Jefferson comes into office, but still there were people who were under indictment or under suspicion. Now, quite interestingly regarding this, the Federalists actually begin to find new ways to enforce the Sedition Act, despite the fact that the Sedition Act had expired. And in 1801, a federal circuit court for the District of Columbia ordered the district attorney there to bring a suit for seditious libel against a Republican newspaper editor. And this is under the common law of seditious libel. So this is a request put forward by a federal circuit court for district attorneys to seek common law prosecutions for seditious libel. And this is a fairly powerful thing and very partisan thing, of course, for a judge to do. And it's rebuffed by the attorney generals, or excuse me, not just by the attorney general, but also by the district attorneys who showed up in court. And this actually turns out to be kind of the final story final act rather, in the story of the Sedition Act's constitutionality. After this, the Federalists will give up on this idea. But it's not the only thing that the Federalists are doing going into 1801. They are also throwing down the gauntlet on the judiciary, and this will be the last bastion for the Federalists to fight against the Jefferson administration. And this begins in a twofold manner. First of all, in December of 1801, Charles Lee, pictured here, the former Attorney General of the United States under John Adams, appeared before the Supreme Court and asked for an order to show cause as to why 4 recently commissioned judges had not, in fact, received their commissions. And amongst them, of course, was this man, William Marbury. These, by the way, are Adams's midnight judges. To be sure, they're justices of the peace. They weren't life-tenured judges. But their commissions had been signed by the president. They'd been approved by the Senate, signed by the president, and then sealed by the Secretary of State. And this is the last act to make the commission valid. After the president signs the commission, the seal is affixed to it by the Secretary of State. And by the way, that Secretary of State in 1801, in the waning hours, literally, of John Adams's administration, was John Marshall. So he had affixed it literally on the last day of the Adams's presidency, in the last hours. But the commissions had never been delivered. There was simply too much to do on that last day in office. And so John Marshall was forced to walk out of the Secretary of State's office, literally at midnight, by the way, and leave behind him all of this work, one of which was the commissions, which still needed to be delivered. Now, the manner in which he goes to the court, Charles Lee does, is to seek a writ of mandamus, which is an order usually given from a superior court to an inferior court or to an inferior ministerial officer, and or to perform a ministerial task. And it orders the person, very much like the writ of habeas corpus, orders that to be done or requires you to come and show cause why it is not done. So this is essentially what he's doing. He's serving notice to James Madison, the Secretary of State, that these commissions must be delivered. Jefferson was likely quite rankled by this. And he, in his State of the Union address, he had obliquely suggested what he had already told several Republicans openly. This is in his State of the Union address in 1802. And this, by the way, is a pivotal year, 1802. What Jefferson suggested in his State of the Union address was that the Judiciary Act be repealed. For the record, by the way, Jefferson here actually changes a very important practice. Both Adams and Washington had gone to Congress once a year to address both houses to give the State of the Union address, which, by the way, is a constitutional duty of the president. But Jefferson sent a written State of the Union address over to Congress that his secretary, who is Meriwether Lewis, by the way, delivers to them. And the clerk of the Congress actually reads it. And this will not be changed for some time. This becomes the standard practice for State of the Union addresses, not delivered by the president in Congress, but actually read in Congress by the clerk of the Congress. Now, in his State of the Union address, Jefferson complained that there were too many federal judges, there was not enough business for them, and all of this cost too much money. This was one of Jefferson's hobby horses. And so the repeal of the Judiciary Act was made on these grounds. And in 1802, Congress did in fact repeal the Judiciary Act. John Marshall, by the way, followed the debates in Congress closely. And within Congress, the High Federalists were absolutely furious about this. They wanted, and they argued that it's unconstitutional to repeal the Judiciary Act. After all, it eliminated newly appointed circuit court judges. And those circuit court judges had already held court. So in essence, you were destroying the life tenure of these circuit court judges. It also represented for the Supreme Court justices an increase in workload, because now, of course, they would be expected to ride circuit. And that could be interpreted quite fairly, frankly, could be interpreted as raising, or rather as lowering their compensation, because you haven't increased their compensation and you've given them extra tasks to do. So John Marshall was well aware, he watched this debate very closely, and he was well aware that the High Federalists were ready to mount a challenge to the repeal of the Judiciary Act. And Marshall was also savvy enough to know that if the Federalists went to war over the repeal, they would likely lose. Congress had already preemptively declared that it had the right to interpret the Constitution independent of the judiciary regarding this. And they had said unequivocally that the repeal was constitutional. And Jefferson, who had both suggested it and agreed with it by signing the Repeal Act, obviously concurred. So what do you do if you're the court? The Supreme Court, if it decides to stand with the High Federalists on this matter, potentially would be in a lot of political trouble. And so in the face of this, what is it that John Marshall does? He does some politicking of his own. He goes to the members of the Supreme Court, his brethren on the bench, and he gets them all individually to agree to return to riding circuit as an inevitability. And then he sits on those circuit courts when Charles Lee brought a test case called Stewart v. Laird, in which he essentially says this repeal of the 1802 Judiciary Act is unconstitutional. And in the strongest of tones, Marshall, while sitting circuit, would turn back this High Federalist argument. Now, it would be appealed to the full bench, and there's no actual Supreme Court term in 1802, but it would be appealed to the full bench, and in 1803, along with Marbury versus Madison, would appear Stewart v. Laird. Now, since you're reading Marbury versus Madison, you can determine what the court's holdings are on their own. But you need to consider for a minute the political context, which is not really revealed if you just read the text of John Marshall's opinion. The High Federalists wanted the Supreme Court to force Madison to deliver the commission. In the companion case of Stewart v. Laird, the High Federalists wanted the repeal of the 1801 Judiciary Act to be declared unconstitutional by the court. And we know that Stewart v. Laird ended with the Supreme Court affirming Marshall's ruling at the Circuit Court that the repeal was constitutional. And you know how Marbury versus Madison ended, because you've read Marshall's opinion. But did the case establish judicial review as we know it today? I would submit to you that in order to understand this, you have to think about, first of all, Stewart v. Laird as a companion case, the fact that that was really the case upon which the High Federalists had pinned most of their hopes. And once you do that and you look very carefully at what, in fact, John Marshall is trying to do in Marbury versus Madison, then you come up with this problem of the way judicial review worked. And this is one of the things, for those of you who will go to law school, at some point you will read Marbury versus Madison in a casebook, and they will tell you that that is the origin of judicial review. This is a complete and utter myth. Nobody believes it, and not even savvy lawyers believe it. The only people who really, I think, believe it are those who have no knowledge of the founding era's history. It was neither the first case in which judicial review was used. It is not the first mention of judicial review. It does not establish judicial review. But it is a very clever defense of judicial prerogative in the face of tremendous power. And I want you to think here, for instance, for a minute, about what goes along with Marbury versus Madison. Consider, for instance, that the Secretary of State, James Madison, doesn't participate in the case. Consider that Jefferson was already beginning to move against other judges. Consider that the Democratic Republicans had already achieved all of their goals by the time and I mean against the Federalists, by the time that the case came before the Supreme Court. Consider as well that they are still on the run, or still on the move. The Democratic Republicans go after the high Federalists on the bench, and they'd go after them with a vengeance. The only way to proceed, by the way, when you have judges with life tenure, is to proceed by impeachment. The Democratic Republicans start with John Pickering, who was charged with, among other things, appearing intoxicated upon the bench, uttering the name of the Lord in a most profane manner. And by the way, Pickering was a very easy pickings. He had clear mental problems. He was likely deranged. But this raises an important question. What exactly is an impeachable offense? And of course, if you look to the Constitution, it says that they shall be impeached for a high crime or misdemeanor. And there's a list of things, actually, or other high crimes and misdemeanors. And Pickering was impeached and removed, but they don't settle during his impeachment what constitutes a high crime or misdemeanor. The Federalist Judge Samuel Chase was the Democratic Republicans' next target. And as a judge, he certainly had behaved in an overtly partisan manner. For instance, in 1804, in an extraordinary grand jury charge in Baltimore, Judge Samuel Chase spent 10 minutes haranguing the Democratic Republicans, which he calls the party of Jefferson, as the enemies of property and liberty. The House of Representatives would end up voting 8 articles of impeachment against Samuel Chase, which include allegations of improprieties during the trials of prominent Democratic Republicans. At one trial under the Sedition Act, Chase was reputed to have said, "It is a pity that they had not hanged the rascal." In another case, Chase refused to discharge a grand jury until it indicted a Republican printer for sedition. So certainly he was an imperious judge, and certainly he had tangled with juries and attempted to confront their independence. And this is, by the way, a problem because the Democratic Republicans believe in the jury as bulwark, and they talk frequently, we'll get to this later, but they talk frequently about the right of juries to decide matters of law as well as matters of fact, and about the incalculable importance that juries play in criminal trials. So Samuel Chase's actions against the independence of the jury were not just because prominent Democratic Republicans were at the bar or in the dock, but also because he had used his judicial position to impugn the institution of the jury. But were these high crimes and misdemeanors? Samuel Chase retained Luther Martin to defend him in his trial before the Senate after his impeachment by the House of Representatives. Now, by the way, this is the same Luther Martin who's the jovial drunk during the Constitutional Convention, and so he's a figure with a long history here in the founding era. And he makes a very persuasive argument before the Senate that a high crime or misdemeanor must amount to some kind of legal offense. In other words, an actual crime. An impropriety on the bench did not rise to that level. Now, Chase would ultimately be acquitted. And the acquittal of Chase, really only by a handful of votes, but the acquittal of Chase is proof positive that impeachment will turn out not to be a political weapon, nor for that matter, even a constitutional one. So if you have somebody in office who's, particularly in a judgeship office, who disagrees with your particular reading of the Constitution, impeachment is not the means to proceed, or at least that is what the history is shaping up to show. It is a legal remedy, a remedy against those who commit some kind of crime. And then, of course, the question becomes what constitutes a high crime or misdemeanor. But it is not really to be it's not certainly not to be a political remedy, and it's not even really to be a constitutional remedy either. Now, this defense of, I shouldn't say defense, by 1804, 1805, the Democratic Republicans have been successful with virtually every change that they've made. And their success stops right at the threshold of being able to remove judges unfriendly to their cause. But John Marshall, and John Marshall's ability to save the Supreme Court as an institution is dependent upon several factors, not the least of which, by the way, was his ability to avoid confrontation with the executive and congressional branch in 1802, 1803, and 1804. And I haven't really talked about everything that he did during this time, but anybody reading his opinions has to be amazed at how he is able to support Jefferson when it's necessary, flatter Jefferson in some cases, and as you'll see in Marbury, be able to retain principles, even scold Jefferson for not fulfilling his duties while avoiding an outright confrontation. Now, on the Supreme Court, we have to turn now from Marshall's kind of saving of a bad situation in 1803, from Marshall's positive effects in building a new kind of Supreme Court. Now, what's quite interesting about Marshall is that he understands from the very beginning the importance of politics, the importance of appearance, all manner of things. One of the things that John Marshall does is when he shows up, he comes in plain black robes. And this is quite different, of course, from John Jay and others who had worn the rather luxurious red and gold laden robes with the chevrons on them that were much more common back in England. So here he is actually adopting a veneer of Republican simplicity in an age when the Federalists still clung to aristocratic pretensions. And so this is a fairly savvy understanding of the direction of the country in 1801. He also arranges for all the members of the court to board together at Conrad's Room and Board in Washington while they are there. They would all eat, drink, and sleep under the same roof during their very short term in Washington. And this, by the way, is a place where consensus can be achieved. And this is quite important because the Supreme Court had, for the most part, delivered its opinions in the British style, which is seriatim, which means one after the other. So in doing this, by the way, what it means is that the judges can all have different reasons for why they reach a particular result, and they all usually state their reasons. And the seriatim opinions are, in some cases, not even written down. They just speak from the bench, and they're only recorded by reporters who happen to be in the room. It's one of the reasons we have a very incomplete judicial record in the 18th and the early 19th century. Law reporting has yet to become a static thing. It's only in the beginning of the 19th century in New York and Massachusetts that an actual legislatively appointed reporter begins to record judicial opinions. And with the Supreme Court, this is true as well. We don't get our first honest reporters until this period of time. Now, one of the things that Marshall does by kind of segged out of that. But the important thing about Marshall is that he achieves a tremendous number of unanimous opinions on the Supreme Court. Between 1801 and 1804, Marshall himself would write 42 unanimous opinions for the court. The ability to forge this consensus is remarkable. It's one of Marshall's signal achievements. And it's important here to know that that what John Marshall is doing is encouraging a kind of consensus and collegiality on the court that allows them to begin dividing up work and allows them to speak as a court with one voice as opposed to a number of different voices. This is a very big achievement of Marshall's. Now, this, and by the way, this unanimity does not last. We have several different periods, and it's worth thinking about this. The ability of Marshall to dominate the court, to dominate the court's other members, would continue through 1812 and its short aftermath. And after that, Marshall's particular rules of internal practice were accepted. And this involves, for instance, the writing of the opinion of the court. Or an opinion of the court. This is an innovation. It's not Marshall's. I mean, he doesn't invent this. But the idea of an opinion of the court is that now you will have not just a unanimous opinion issued by the court, but that the Chief Justice can assign an opinion of the court, which will go to one person in particular, and that person will write it. And the idea, of course, very early on is that it will be a unanimous court speaking for the majority. Or the opinion of the court will speak for the majority. Marshall, of course, is also able, through the use of unanimous opinions, to stop people from dissenting. And this is pretty remarkable. Between 1816 and 1823, for instance, the court issues 302 opinions. Only 24 of these were dissents, and only 8 were concurrences. So you have a remarkable number of unanimous opinions that continue. Now, another aspect, and this is through the acceptance that the court, that the Marshall Court justices took with the issuance of an opinion of the court. They also write their opinions in order of seniority. So the opinion of the court is assigned by the Chief Justice. That's the first opinion, which will be printed in the reports. And then after that, you will have concurrences and dissents in order of seniority. And this actually, once again, encourages a kind of unanimity. And a lot of justices kind of silently acquiesce, even when they don't completely agree with an opinion. Now, I mentioned that we have this large number of unanimous opinions that continues through 1823. After 1823, the court justices proved unable to control, and Marshall no longer dominated the court. We'll come back to the later Marshall Court at another time, but I don't want to give you the idea that the entire Marshall Court, the period of the Marshall Court, was one of unanimity and happiness. It was not. Let's think really quickly, though, about what the court terms actually looked like. First of all, the court met for only several weeks out of the year, rather than the current 9-month term that we have today. Once business before the Supreme Court picked up after 1816, they would issue an average of about 40 opinions a year. So they heard 40 opinions. Unlike today, opinions would be issued within days or weeks of hearing a case. The Supreme Court justices had no clerks, no secretaries, and hardly even a law library of their own in Washington. These were factors that likely lent weight, by the way, to Marshall's attempt to have them pool resources by coming to consensus on legal issues and dividing opinions up amongst themselves. And it's notable here that Marshall kept most of the workload in these early years on himself. He did the lion's share of work for the court. So he really does actually issue these opinions on his own. The kind of other thing we need to consider here is that the nature of oral argument before the court was vastly different. If you listen to oral arguments before the court today, nobody gets a word in. Somebody will start, they'll talk for maybe 10 seconds before they are interrupted by a string of questions that come from various Supreme Court justices. And this is all that happens. So oral arguments is a question and answer kind of moot court thing now. But back in the days of the Marshall and the Taney courts in the 19th century, when oral arguments were delivered, they were orations. They would go for hours. Sometimes they would go from one day to the next day to the next day. So they oftentimes lasted more than 4 hours a day. People would pack the galleries to listen to people deliver oral arguments, for which some of the most famous Americans actually showed up. Daniel Webster, for instance, is one of the great arguers, great orators, who shows up before the Supreme Court. He, for instance, delivers one of the oral arguments in McCulloch v. Maryland. In fact, if you read his oration, which was written down and submitted to the court, it looks an awful lot like Marshall's opinion. So you start to get the sense that these oral arguments were very important. And in the absence of clerks, oral arguments oftentimes end up being largely plagiarized in Supreme Court opinions. So the last thing I wanted to mention, and I've already talked about it, there's a difference between the early Marshall Court, 1801 through about 1819, 1820, and the later Marshall Court, the Marshall Court of the late 1820s and the early 1830s. And we'll talk about the late Marshall Court at a later time. But I hope you now have an understanding of the political atmosphere in which the Marshall Court had to operate and the scope of achievement that we can ascribe to John Marshall in rescuing the court from what was a very precarious political position between 1801 and 1803.